Breaking news! Something truly unprecedented just happened, and it's about to change the way you think about your digital life. This time, it's actually big, not just another headline. This is the kind of news that makes everyone stop and pay attention. The Supreme Court just handed down a landmark 9-0 decision, sending shockwaves through the legal and tech worlds alike. That's right, unanimous. 9 justices agreeing is rarer than a cat barbershop quartet. It almost never happens. Which tells you just how important this is. They declared your digital life, emails, texts, DMs, even your embarrassing search history, is now protected under the Fourth Amendment. That means your private messages and online activity are finally getting the same respect as the papers in your desk drawer. The usually solemn Supreme Court was buzzing. You could feel the energy shift as the news broke. This was history in the making. Reporters scrambled, lawyers celebrated or despaired, and somewhere, a government agent put down a folder labeled "Everyone's Memes." Even the most seasoned legal experts were caught off guard. This ruling slams the door on the government's ability to casually rummage through your digital drawers without a warrant. No more phishing expeditions through your inbox or cloud storage just because they feel like it. For decades, the law lagged behind technology, stuck in a time when tin cans on strings were high-tech. The rules were written for a world that barely imagined the internet, let alone smartphones and social media. Today, the court finally said, "Oh right, the internet exists. Let's make a rule." It's a long overdue update, and it's about time. This isn't just a dry legal update. It's a fundamental shift in how your rights are protected in the digital age. It's about whether the government needs a real reason to read your messages or emails. Now they can't just snoop around without a solid court-approved warrant. Our entire lives are stored on servers. Friendships, finances, late-night shopping habits, and even those awkward group chats you wish you could forget. Until today, the legal framework protecting that info was as sturdy as a wet paper towel. It was flimsy, outdated, and left you exposed. This decision is a digital declaration of independence. It's a bold statement that your online life deserves real protection. Every day, you hand over data to third parties, your phone company, your email provider, your favorite social platform. You trust them with your secrets, your plans, your memories. The old thinking was, you gave it to them so it's not private. That logic left millions vulnerable to prying eyes. That argument is now officially dead. The court has buried it for good, and your privacy just got a major upgrade. The Supreme Court just said, using the internet doesn't mean you surrender your right to privacy. Your digital life is now shielded by the Constitution. It's a stunning victory for common sense, for personal freedom, and for anyone who's ever worried about who might be watching online. Let's break it down. The Fourth Amendment now fully protects your digital communications stored by third parties. Law enforcement can't just ask Google or Meta for your emails or DMs with a simple subpoena. They need a warrant based on probable cause. This wipes out the old third-party doctrine from the 1970s, which said you lost privacy by using a tech company. Now, giving your data to a third party is recognized as a basic requirement of modern life, not a choice. The impact is immediate. Every American with an email or smartphone just got a massive privacy upgrade. Law enforcement must now meet the same high standard for your DMs as for searching your house. In short, your weird fan fiction is now constitutionally protected. The face of this fight? It's not who you'd expect. Not a high-powered activist, but Sarah Thompson, a freelance graphic designer from Ohio, juggling deadlines and coffee refills in her cozy apartment. Her journey began with a confusing, almost surreal email from a federal agency. Her digital records had been swept up in a broad investigation, without her knowledge or consent. Sarah wasn't a suspect, just digital collateral damage, caught in the net of a system that didn't see her as a person, just as data. Most would have moved on, shrugged it off, but Sarah got mad. She felt violated, like someone had read her diary and decided to fight back, refusing to let it slide. She hit a wall of bureaucratic silence. The government insisted they'd done nothing wrong. They used a subpoena, not a warrant, and the law as it stood was on their side. No apology, no explanation. With help from a civil liberties group, Sarah filed a lawsuit, not for money, but for principle, determined to stand up for everyone's right to privacy in the digital age. Her argument was simple but powerful. How can we have privacy if the law pretends our digital lives don't exist? She challenged the very foundation of outdated privacy laws. She said her emails and DMs are the modern equivalent of private letters, always protected, always personal, deserving the same respect and legal safeguards. Her case, Thompson v. United States, challenged a dangerously outdated legal idea, forcing the courts to reconsider what privacy means in a world where so much of our lives is online. Sarah became the accidental hero who forced the courts to confront the reality of digital life, inspiring others to question how their own data is treated. Her fight wasn't glamorous, but it changed everything. She showed that ordinary people can spark extraordinary change, even from their living rooms. Sometimes it just takes one person to stand up and remind us all that our digital lives deserve protection too. To appreciate today's ruling, you need to know how flimsy your digital privacy was yesterday. The law was the 1986 Stored Communications Act, written when Top Gun was in theaters and the internet was science fiction. Under the SCA, the government could get your old emails with just a subpoena. No judge, no probable cause. This created a bizarre rule. Your email was more private on day 179 than day 181. Law enforcement exploited this loophole for decades, scooping up data with little oversight. The third-party doctrine said you had no privacy in info shared with a company. Sarah's case blew the lid off this system. Her years of emails were taken with a weak legal tool. The government didn't have to prove she was involved in a crime, just that her info was relevant. This low bar meant countless innocent people's data was swept up. Today, the Supreme Court called that system what it was: unconstitutional. Sarah's legal battle began with what felt like a crushing defeat, a moment that could have ended her fight before it truly started. The district court dismissed her case outright, declaring that the law was clear. There was no expectation of privacy in data handed over to tech companies, no matter how personal. Most people would have given up at that point, overwhelmed by the setback, but Sarah refused to quit. She decided to appeal, determined to keep fighting for her rights. The appellate court, however, saw the situation in a new light, questioning the old assumptions. They acknowledged that the rapid evolution of technology had fundamentally changed the way we live and communicate. In a stunning reversal, the appellate judges sided with Sarah, declaring that you don't automatically forfeit your Fourth Amendment protections just by using modern technology. They compared her digital records to a locked filing cabinet in her own home, private, protected, and deserving of constitutional safeguards. This groundbreaking decision contradicted decades of established legal interpretation, setting up a direct conflict with rulings from other courts across the country. That circuit split made it almost inevitable that the Supreme Court would have to step in and resolve the issue once and for all. Sarah's persistence and courage forced the highest court in the land to finally confront the question of digital privacy in the modern age. Her case became the vehicle for a new era of rights, opening the door for future generations to claim privacy in their digital lives. Sometimes, the legal system needs a push to evolve, and Sarah was the one who gave it that necessary nudge. What began as her loss ultimately became a pivotal turning point in the fight for privacy. The battle was far from over, but for the first time, hope was alive and growing stronger. At the Supreme Court, the debate boiled down to one question: is your email a postcard or a sealed letter? The government argued emails are like postcards, open to anyone handling them, so no privacy. They said using a service means you give up your right to keep data private from the government. Sarah's lawyers countered, your email account is like your house, a place for years of personal correspondence, photos, and records. The third-party doctrine was never meant for the entire contents of a person's life. Digital life isn't optional, it's a necessity. Forcing people to choose between modern life and privacy isn't a real choice. The Fourth Amendment must evolve to protect our digital papers and effects. The justices had to decide, do our rights follow us online? The day of Supreme Court arguments was electric. Justices from both sides grilled the government's lawyer, troubled by the idea that using the internet meant giving up privacy. They asked, if I store my diary in the cloud, do I lose privacy? Could the government get a lifetime of my emails just because they're relevant? The Carpenter case loomed large, where the court had protected cell phone location data. The justices seemed to see digital communications as just as sensitive. They wrestled with practical questions, emergencies, foreign intelligence, but kept returning to one idea: the Fourth Amendment must protect our digital lives. The old way of thinking was on its last legs. The stage was set for a historic decision. This morning the decision came down, a thunderclap, 9-0. The court declared you have a reasonable expectation of privacy in your digital communications, even when stored by a third party. The third-party doctrine for digital content is dead, the Chief Justice wrote. Using email or messaging services doesn't mean you forfeit constitutional protection. The court rejected the postcard analogy, embracing the digital house analogy. Now, the government must get a warrant, supported by probable cause, to access your emails or messages. The arbitrary 180-day rule is gone. An email from 10 years ago is as private as one from 10 minutes ago. This is a total victory for Sarah Thompson and digital privacy. The decision is unanimous. Privacy is not a partisan issue. Your digital world is now, officially and constitutionally, your own. The ripple effects are immediate. Law enforcement's easy access buffet of digital info is closed. Now they need a warrant and probable cause. This restores a critical check on government power and protects everyone's private conversations. Journalists, activists, and everyday Americans can use digital tools with new confidence. Tech companies now have a constitutional shield. They must refuse to turn over user content without a warrant. This ruling will lead to stronger privacy policies across the industry. Of course, new questions remain. Metadata, encrypted data, overseas storage, and AI surveillance are all future battles. But today's ruling is the foundation for all future digital privacy rights. It establishes a core principle. Digital privacy is a fundamental American right. The fight isn't over, but today, we won a huge battle. Your digital life is yours, by law, by right, and by the Constitution. The internet just got a lot more private. And that's real breaking news.